Are we on? And welcome, folks. This is the Joint Justice Oversight Committee. This is our last meeting of this between the two sessions. This will be our last meeting until probably next June, maybe, unless something comes up during the session. Today, we're continuing some of our conversations that we had last Friday here. We'll start with the item of Rule 74, which is the appeal process for a furlough interrupt. There was issues that were brought before us by Department of Corrections. And it appeared as if a lot of those issues were more administrative issues than anything that really needed to be taken care of by statute, but we're not sure yet on that. So we have asked the Department of Corrections and Prisoners' Rights Office and the courts to see if they could meet prior to this meeting today that we're having and see if they could find some resolution or clear up some misunderstandings. So we have with us in person, DOC, Prisoners' Rights. And on our screen, we have Judge Zone, is that Zone for the courts. And I know that we also have Michelle Charles, our legislative counsel, is also zooming in. So I'd like to start with bringing the three folks, DOC, Prisoners' Rights, and the judge. And I know the judge will be participating electronically, but here he is. If you three could come on up, or at least two that are here in the room. Yeah. And the document we worked off of last week on our webpage to remind us. Okay, so I'll turn it over to you folks, and if you could just identify yourself for the record, and then whomever is ready to start, can start.
Sure, I'll start. So it's Nicholas Demmel, DEML, Commissioner in the Department of Corrections.
And I'm Emily Carr. I'm the General Counsel for the Department of Corrections.
And I'm Emily Trito. I'm the Supervising Attorney at the Prisoners' Rights Office, part of the Defender General.
And I'm Judge Tom Zone. I'm the Chief Superior Judge.
You're muted.
I shouldn't be. Let me see. I apologize.
Not muted, but we can't hear you.
We can't hear you.
Uh-oh.
Can you hear me now?
How about that?
You need to turn up your volume on the audio.
How about that now?
Can we hear Corey? Corey, can you say something just to see if it's working?
I can hear the judge. I think it's.
Oh,
Can't hear you either.
Can't hear you either. And
Oops,
Michelle?
Michelle.
I can hear you, Corey, Senator Ferrant.
There's that little thing you can hear.
That little round thing on.
So let's hold off. We can't hear any of you.
I see coming.
Try again, she said, Alice.
How about that? Is that working?
Yeah,
Hey.
there you go.
I'm sorry.
No, it's
Just-
not you. It was on our end.
Well, for the record, I am the Chief Superior Judge Thomas Zone, or as many people have been calling me, you're the new Judge Grierson. So good morning.
Can you turn up the volume at all?
I'll ask.
Huh, okay. Maybe if we could close the door. Al, could you just close the door, please? Our Corrections does have a document. Again, it's dated November 5th, but it's on our webpage for the current date today. So is the commissioner starting or Emily Carr?
I'd be happy to start to frame out the discussion. So at the request of this committee, the three groups that you identified, the Department of Corrections, Prisoners' Rights Office, and the courts, were able to meet earlier this week to discuss some of the challenges being faced under the Rule 74 issue. In advance of that meeting, the Department of Corrections internally got together and brainstormed some ideas that we thought may help to alleviate the burden on the department and on the courts in particular, and presented some of those ideas during the meeting on Wednesday. I think we were able to get to agreement. It was a very productive meeting. Get to agreement on some of those topics. I think there are some outlying topics that we can discuss, and happy to do that and find a way through the situation. So a couple of the things that the department had thought would help alleviate this burden were to have some form or forum for a filtering of Rule 74 petitions that didn't meet the basic criteria laid out in the statute. So the department offered that we could have some type of filter clerk within the department who could help certify whether or not those individuals who are filing petitions actually met the basic criteria, that the revocation happened after January 1st, that it was greater than 90 days, those types of standards set out in the law. We also offered that we would work with the courts to alter the court form that would lay out the criteria for petitioners, particularly pro se petitioners, who could then say, oh yes, I meet all these criteria. It was very clearly laid out in the form. We gave the same offer to the Prisoners' Rights Office that we would help, inform, their forms or give advice on where we thought that criteria could help clear up some of the cases that don't meet the threshold that we're talking about. And then we talked about potential fixes or adjustments to the language in the statute itself. And I think this committee noted last week that in general, the statute captures, I think, the intent and the language that you wanted, but we do think that there are some areas for clarification that would help ease the burden, certainly on the Department of Corrections, but also the courts. In the meeting itself, I think we got to agree on a few of these points. So I think everybody present agreed that some type of screening of cases that don't meet the basic threshold is necessary. One of the ideas that we discussed as a group, and I don't want to speak out of turn, so please correct me if I'm misrepresenting our discussion, but one of the things we discussed is having the Department of Corrections file an initial motion with the court or a statement saying that it did or did not meet the basic criteria. The court knew before the Department of Corrections was required to accumulate and then send over the record that it did or did not even meet the basic standard. Another thing that we talked about for a while during our meeting on Wednesday was the venue of these petitions. And so a lot of the petitions are being filed in one venue. And I think all parties agreed that it would be best if those were filed either in jurisdiction where the incarcerated individual is housed, so the facility location, or where they had previously been under supervision. That way, the petitions were spread out amongst the judicial jurisdictions in the state, as opposed to all being filed in one space. We, I think, agreed with the courts that, pending any legislative changes that may happen, we're happy to work with the Civil Oversight Committee on creating a court form, as we discussed. And I think those were kind of the top lines of what we were able to get to agreement on. Beyond that, I think there are a couple additional things that we could talk about that the department would like that we couldn't either get to agreement on or didn't come up during our meeting. And the last thing I wanted to just add before we move to some of the other participants is, this legislation took effect on 1 January of this year. Concurrently to that, the department rewrote its policy on furlough revocations. And that also took effect on 1 January. That policy, I think, very clearly lays out the intent that you all were trying to see with this legislation. And I think the department has done a really nice job in good faith of trying to capture that intent in our own policy, so that we're not doing interruptions for short periods of time, so that the folks that we are revoking from furlough are people that either have demonstrated that there is nothing that the department can do to monitor and supervise them while they're on release, or that their actions were so egregious that it warranted some type of revocation. So I'd be happy to share that policy with you all. That's published on our website. But I really wanted to highlight the fact that the department, I think, has gone out of its way to try to ensure that we are in conformance with your intent and with the legislative intent of the statute. Emily, I don't know if you have anything else to add.
I wanted to add one thing about this screening process that we had discussed as the group on Wednesday. In discussing that situation, we realized that we might need a legislative change to the statute because we're trying to filter them out, filter the cases out, making sure the workload on the department isn't that heavy with compiling the agency record, which we have to do automatically within 30 days once the appeal is filed. So because we're trying to do the screening process, we would like to not have to provide the record until ordered by the court. And Rule 74 requires us to do it within 30 days. So if we could, I think the whole group agreed that adding some language in 724 about the department not having to file the record until the court orders us to do so would be helpful.
I just asked a question there. So right now, it goes through one system, one court. Is that correct? Or because one of your recommendations is that when a petition is filed, it will go to the court of the jurisdiction where the person is housed, which is different. Now, without that change, doing that, where do the petitions go now?
Well, I think, correct me if I'm wrong, either of you, but I think it's like a de facto situation where, in fact, most of them are coming to one jurisdiction. It doesn't necessarily need to be that way.
What jurisdiction are they coming under right now?
Washington County.
Washington County. So if the recommendation is accepted and the petitions go to that court where the offender is held in that facility, and then you want language that allows the department extra time to file, is that going to be different at different parts of the state because the courts may see it differently?
Well, we're hoping based on the statutory change, the language that would be changed in the statute, no. And also hopefully with Judge Done's assistance, that we could get all the courts on the same page on how to handle these.
That's always the hope.
I'm looking at the list, the memo that Commissioner Gemmell has provided. And on the top of the second page, you want explicit statutory clarification in the interest of judicial economy and to eliminate ineligible filings, which would become an unnecessary workload. So does this mean that you would have some sense up front about which filings are ineligible? I'm trying to sort out, are you suggesting that all filings would be held, would not be processed immediately, but how are you determining which ones are ineligible? It sounds like a more of a conversation, statutory conversation than just let us put things off beyond 30 days.
So the department holds the records and for cases, the petitions that don't meet the basic criteria. So let's say it was a revocation that occurred before January 1st. We would be able to determine based on our record that clearly this doesn't meet the basic language of the statute, send a motion to the court asking that the motion be dismissed or because it didn't meet those basic criteria. On the areas where there's disagreement or differences of opinion on whether it meets the criteria, those certainly would go forward and the department could produce the record at that point.
Thank you.
Or cases that clearly do meet the criteria, obviously would go forward.
Just to follow up on that, if I could, if I understood right, the filter clerk, as you're calling them, would be in DOC. And I'm wondering, are prisoners' rights fine with having that ability in DOC to bounce those back?
That's a good question, Representative or here.
Senator.
No name tag. So it's a good question. And, you know, we were discussing on Wednesday a little bit the fact that in years past, some clerks would consult with the Prisoner's Rights Office about whether a habeas is habeas, and we served that screening role. And that seemed to always work out because it was always in good faith. We would take that role on as a neutral before swinging into advocate mode when the case was underway. Judge Zone at our meeting on Wednesday pointed out that, look, if there's disagreement, it's ultimately going to be a judge's decision. So the key would be to have that just clarity up front about what's happening. So I think in most cases, I did a survey of all of our offices in Rule 74 cases this morning that we've seen so far, which is about half. I think that the other half are still in the pipeline coming out of DOC. About 3/4 of them, I'd say 2/3 or 3/4 are clearly within the statute. They're that have been filed pro se. They're 90+ day interrupt after furlough revocation. And so I think and so for those, I would hope that the rule continues to be filed within 30 days. You don't need to wait. If you don't disagree, you shouldn't have to wait for a court order, just file it. That's what we currently do. And for the rest, then the department would file some statement saying this isn't, and that can be not even one paragraph, one sentence, a box check. It's a pretty simple administrative thing to say this is not 90 days, this is not a furlough violation. And then the suggestion was made, maybe if it is a case staffing, file the case staffing so that we can see for ourselves what was it if it wasn't within the statute. And then it can be for the parties to disagree. So if there's something where there's room for disagreement, that would be rare, I think. The statute's actually pretty black and white. Then that could be brought before the judge and figured out. And if there's not, then the court would dismiss it. And often prisoners' rights, we're already sort of serving some of that filtering role because whenever we get a case, if we don't think that it has enough legal justification for us to be able to ethically proceed with it, we will often call the person and say, I'm sorry, this isn't going to go anywhere. I've had a number of clients who I knew personally who I saw that they filed and I knew they hadn't been on furlough. So we called and said, and they, you've got to dismiss it. And most people hear that legal advice and they're disappointed and say, okay. The trouble with that is that at that point, the department may already have put in some effort preparing the record. And so the idea would be to spare them that wasted effort if it's just going to get dismissed. But what we wouldn't want to see happen is have the record be delayed while things where there's real room for disagreement, if there's motions practice and we're exploring the contours of the law, the record should be produced in that situation. But the vast majority of cases are pretty black and white. We either don't need to rely because this case is going nowhere, or we do. So, but did I answer your question?
Absolutely.
In my simple brain, it appears as if the first step to really deal with this is clarify the form. If you clarify the forms of the petition, you clarify the criteria part of the petition, it's going to weed out a lot of problems that you're having right now that will then help on the filtering end, that will then help in terms of the appeal end. That's my simple way of looking at it. Because it appears that the form, the petition currently is not very clear in terms of the criteria for eligibility. Does that make sense? That's your first step in the process.
Yes, it makes sense to the Department of Corrections. We think a clearer form, check boxes, laying out the criteria would be helpful to provide to the incarcerated population.
It would. I think that we're at this stage, I think we have to agree to disagree is what all of the criteria are. For instance, the statute, the part of the statute that says you can appeal, that it's appealable, doesn't specify technical violations. Other parts of the statute do specify technical violations. So 724C doesn't mention technical, and the other parts do. The notification requirement in 724B, the standard of review in 724D specify technical. And so I imagine, please correct me if I'm putting words in your mouth, the department would like to see it has to be a technical violation as a requirement on the form. But my office's position is that that's narrowing it and more narrowly than the statute says. So we're not going to tell people you have to, it has to be a technical violation when that's not what 724 says.
So I'm looking at language, and C says the appeal shall be based on a de novo review of the record. Is that in conflict, that de novo review, is that in conflict with the technical violation section D?
Well, I don't know that those are in conflict. Section D lays out the standard of review for a technical violation. 724C says who can appeal, and that appeal is a de novo review of the record, and the appellant may offer testimony and other evidence for good cause. I think what makes technical violations different under the statute is that there's this presumption of an abuse of discretion unless certain criteria are met under 724D1. And that wouldn't apply to a non-technical violation. For a non-technical violation, there wouldn't be this assumption that 724D wouldn't apply. But so we're getting into the weeds, and I think that we're also straying into the substantive policy rather than how to administer things efficiently. But I was just remarking that I think we can agree on some ways to make the form more explicit, but I'm not sure that with the statute as written, everyone's going to be satisfied that it's narrowed as much as the department would like to see it's narrowed. And that's not because we're not willing to work with the department, it's because of good faith reading of the statute.
And Teresa?
So I'm trying to, I realize that we're not going to make a policy change here, but I'm trying to make sure that I understand what you're saying in that you're saying that D, which I mean C, excuse me, put the glasses on, doesn't specifically say technical violation, even though this whole section deals with technical violations. And is that your assertion that C then opens it to more than technical violations? Is that what you're saying?
Yes, and in the terms when this has come up in the courts already, in that context, we'd say if the legislature had wanted to say technical in one area, not the other, usually variation is presumed to have a meaning.
Yeah, I think that might indeed be something that needs to be looked at. If that's causing problems here, because I think the legislative intent was technical violation, if I read this correctly, but thank you
No
for
problem.
clarifying.
I just think it would be putting the cart before the horse, I think, to have the form be the thing.
I understand what you're saying.
Away in that
Mhm.
discussion. More broadly, I just wanted to, if I may, if there are no further questions at the moment. This is a brand new procedure. It's new to everyone. And it's coming at a time when the department's legal team has undergone a lot of changes. They basically lost 3 lawyers at once out of 4. And there was a bit of a backlog at the beginning because the courts didn't initially know how to process these cases coming in. Most of them went to Washington County. And we worked with the clerk there, and it was a little bit while before the clerk was clear on treating them in some ways the same as other prisoner cases and sending a copy to us, but it's different because how they come in through the department. It's all just different. And as a result, there was quite a backlog. For 2021, in theory, these cases could have started coming in February, January, as soon as the statute took effect. But what we really saw was the whole year's cases up until that point came in July and August. So it felt like an avalanche and it felt like a lot. But at least from where I sit, it's working out. I'd like to see the process play out some more and see how these cases shake out. We've only gotten one substantive decision so far in any of them. That ended up being a case in terms of actually looking at the merits and not resolving on some preliminary issue. That was a case where someone had a 4-year interrupt for having contact with a person he wasn't supposed to have contact with. No new crimes or anything. And the judge looked at that and thought actually 5.5 months that he has served for this are enough in order to. These hearings are usually pretty quick. We've scheduled a bunch of them for 1 hour each in December lined up. We just have afternoons in Washington Civil doing 1 hour hearings. Reminds me of doing parole cases that we do all the time. It's not a full soup to nuts, a civil action civil case. And so before making major changes, I hope that we get a chance to see how this plays out. To some extent, I think so far, from where I sit, it's time well spent, because even if in 3 cases or 4 cases, only one results in any sort of reversal, which would be a good thing, because it would mean that the court looked at it and thought DOC is doing it right, then that's substantial resources saved. The person is no longer incarcerated. There's the savings that would come from people being released who didn't need to be incarcerated on technical violations aren't captured when we're just looking at this specific legal process, but are considerable.
I think if I may, unfortunately, the department's experience has been a bit different. I think we're all in agreement that there was a presumption of an avalanche of cases coming through as this took effect, and that at some point that would abate. But I can tell you from the experience of the folks who work in my department and with the Attorney General's office, who's also, trying these cases on our behalf, that burden has not abated at all. And we would have expected that to happen by now. In fact, I think we're continuing on the pace or increasing the pace that we have been. And those burdens, I think, aren't felt so much at the 1-hour hearings, but in the department where we have somebody whose job it is to run our legal education, spending their entire day, every day of the week, processing Rule 74 records requests in order to comply with the rule. And so without changes, we are committing vast resources to being able to comply with this rule as it stands. And while I respect Emily's point about wanting to save people, the time incarcerated, I think that the department's policies are fulfilling that intent right now. The policy about furlough revocations, because we have decreased the short-term furloughs. We are only revoking people who, after multiple attempts by the department to get them on supervision and have them comply with the rules, are unwilling or unable to comply, and it forces us to keep them in a different setting where supervision can occur. So, I respect her position, but I don't think it captures the impact that this is having in the Department of Corrections.
I'm gonna ask a really stupid question. Stupid. So this statute, this law, the appeal process for furlough interrupts that are longer than 90 days became effective January 1st of this year. Shouldn't that law just apply to those folks going forward who, on the 20th of January, they have a furlough interrupt that's going to end up being longer than 90 days? So come February, March, come the end of April, if they're still in, then they could appeal. And folks who prior to January 1 that had a furlough interrupt that was longer than 90 days, do they qualify for Rule 74 appeal?
And the department's position is no.
Is that the crux of the issue here or not?
It's not representative, because nearly all of the cases we've seen have been from furlough revocations that occurred after January 1. I can think of one case that I know of where the person was interrupted in 2020 and then sort of had that interrupt extended in 2021. But almost all of these have been people who were, as of January 1, were on furlough or received furlough after January 1 and then came back in. These are all new.
The department has seen old ones. Like last week, our clerk received one from a decision made in 2017. So some of them are getting through. Those are the exact types that we're trying to prohibit. So our clerk doesn't have to worry about getting the record together and sending it to the court and spending her time doing that. Ineligible.
That's a case where we would be in agreement. that if we saw it early enough to talk to the person, and of course, we can't tell someone who doesn't want prisoners' rights representation that they have to dismiss the case and proceed per se, but we do try to educate people. That would be a case that would the proposed screening process prior to producing the record would be a good idea. But we are seeing a very large number of 90+ day revocations for technical violations. My understanding last year when this bill was coming through the first time is that under General Valerio testified based on information he had in the department that about 75 or so a year is what had been seen of 90 or more days on technical violations. We're already on track for a lot more than that. I think we get notified of 4 or 5 a week. And so, well, I think that it's a much larger policy conversation than what today's hearing is about. And I think I'll have to agree to disagree with Commissioner Dummel about the appropriateness of so many of these violations. The numbers, they've become quite lengthy. I had never started seeing 4-year interrupts until this past year when this new policy came out. And the thing about the interrupts is the department still checks again, especially for listed offenders, before furloughing the person. When the 4 years is up, they don't hit the street. They just get to be considered. And so the department's new policy effective January 1 is having people even be considered, some of them, depending on where they fall on this little grid that they've made, until 2 or 4 years. For a while, the department had been only doing 1 year at a time. And so perhaps it's true that there are fewer short interrupts happening, but these lengthy interrupts that really ultimately drive the numbers because people serve such significant amounts of time, driving the incarcerated population numbers, they are continuing and increasing on technical violations.
But the reason we did this was because we didn't wanted the longer, the 90-day and longer furlough interrupts to be the ones we focus on, not the 3 or 4 day. It was also part of our effort to reduce the number of furloughs and use other methods like parole and so forth. So, the furlough system, I think, is fairly unique to Vermont. And it has its great things and has horrible things with it. And what I see, and when I get an email from an inmate or his parents or whoever, it's always, they had it out for me. They don't like me. It's really begin to wonder. And then when I hear from constituents who constantly trying to deal with this guy, or mostly guys, it's, what can we do? They're constantly not following whatever rules were set up under the furlough. That frustrates the local probation parole, who are already under tremendous stress because of the staff shortage, and their corrections officers are now in the facilities. I think it's like a perfect storm. And so we have this little problem, and I call it little, because luckily it's, it's still a rather small amount of number. I think we need to get together and work on it and come up with some solutions that if it takes legislation, we can do that. But the real problem is a certain minority of offenders out in the community are just not following anything. They're doing what they damn well please, and this comes from a guy who's I think fairly progressive in terms of corrections. But and then when they do get in, they file a case, right? And complain because this guy is out for me, or what she said isn't true. They're domestic abusers, for example, and they say, no, I didn't contact her, she contacted me. I don't want to deal with all that. So I think there needs to be a way to change the statute if we need to. But to also make sure that who we're furloughing in the first place can make, sometimes I scratch my head when I see some of the names of people that are furloughed. Frankly, no, honesty. And yes, I want to see our numbers down. I want to see who's locked up, being people that need to be locked up. But unfortunately, there's a small group who are on furlough who may not be committing crimes, but are doing an awful lot of not following any of the directions that are provided for them. And I think that's part of the problem. So, and I'd love to sit down with you and Matt Valerio and the commissioner in January and see what changes we need to make. We need to make the furlough system work, or we need to go to just straight parole and not have furloughs, except for medical or, some of those that are absolutely necessary.
Well, maybe once the presumptive parole starts to really kick in, might then balance out the furlough systems. That was the hope, but it's going to take a while for the presumptive parole piece to be rolled out. It'll take a few years because we were graduated in terms of who could apply, who would qualify. I'd like to allow time for the judge to weigh in. So Judge Zone.
Thank you. Thank you. And thank you for allowing me to appear
Oh, we can't
electronically.
hear you.
Uh-oh.
Not
I
now.
think it's on our end again. I'm
Do you hear
not
me now?
sure. Corey, can you say something and see if it's on our end?
I think it's on your end because I can hear the judge.
It's on our end again. Sorry, we'll try again. Hang on.
How about now?
There.
Could be a way to shorten our committee.
You require us all to go out.
And if we don't want to hear your testimony, you've got the
Right.
control.
We could also require, encryption.
I think it's in this room, because the other rooms we've been in haven't had any problem at all.
But we didn't,
Volume or,
We
yeah,
never had this room.
but we haven't had,
Are you ready? Did the other day.
How about now?
Okay, go ahead.
okay, let's see, Judge.
How about now?
No. Uh-oh.
All right, I'll email IP then.
I think we need technical
Yeah.
assistance.
It happened the other day.
In this room or a different
In
room?
this room.
Yeah. it was in this room. I mean, we were on a couple, or one other committee this summer, we've been in 11, 9, and 24, and we've been able to hear witnesses very easily and all that stuff up on the screen. This room does not have that. It's a little bit of a glitch.
So Judge, we're going to be on hold here a little bit because we need to get some IT folks here to help us, and that's going to take a minute or two at least. So I would just ask folks
You never
to
know.
hold tight.
Cinderella picture.
Well, Senator Perrant, you and I can have a chat, I guess.
Yeah.
You could be saying anything.
Yeah, you folks can just spew away. Nobody will know.
That's right. Say whatever you want.
But for us, these microphones are really sensitive.
The secret will be just to get them to nod their heads, yes.
I know, we don't
That's a
know.
question.
That is a good question. Would they be able to be heard on YouTube?
I think we probably would, so that's why I wouldn't say.
We can't hear it.
inappropriate.
As you're saying,
Whatever you
Corey.
said. Go.
You could chat, let us know
I
what's
was gonna
going
say, it's
on.
the cautionary thing about encouraging people to say whatever they want.
Yeah.
It might be out on
Yeah, it might be out on.
YouTube.
Well,
Would
it's
it
an
be
experiment.
Faster to send a physical person to IT?
Yes,
Yes,
is it Sade?
yes, I've already emailed.
You could send a physical person.
How many go get him?
Room.
I think a physical person is.
Why don't you take a run?
She's going.
Oh, she's right. Okay, he's upstairs, right? Room 40, whatever.
Down in the second.
He's coming down.
Could we temporarily go to the,
Well. Oh, Bill Sorrell's on, Bill's not here.
Yeah.
Heather's not here. And Rose is not here, is she? No.
she's on Zoom.
Yeah, Zoom is on, the voice isn't
Zoom is not
working.
working.
And then
Actually, it can be heard on the live stream.
you can?
Yeah.
They are heard on the live stream.
Yeah.
So it's, so you folks have to be careful what you're saying, because you can't on live stream.
You can't say anything you want.
That we can't get on YouTube.
Oh,
I take back everything I said about Senator Bruce.
Yeah.
Well, this is a trial run,
Well,
folks.
this is-
We're- When the session starts, and we're in hybrid.
They claim that they.
And sometimes to give people a balance here, our IT folks may be helping another committee, so they may not be as readily available. Right now? Uh-oh, heard something.
Yeah.
Something
Or
like
they'll
that.
invite like Steve Bannon to come.
Speak.
And I'm like,
On Zoom, Judge, can you just say hello or start speaking?
Good morning.
Oh,
Hey.
okay, that's even louder, that's great.
That's good.
All right.
Don't go anywhere yet. Hang on. Hang on. So we're good to go? Okay. So Judge, welcome again.
Well, thank you. Thank you for allowing me to appear electronically. I apologize for the inconvenience of any difficulties that causes. I did have a meeting this week earlier with our justice partners who are there today, and I would concur with what has been stated as far as the consensus that we were able to build. As far as anything beyond that, I would note that we do have, it's a new statute. As was pointed out earlier, new statutes sometimes have areas that courts will be called upon to determine what was the intent and what is the policy being advanced. And so the question about that was raised today about whether this is only for technical violations or whether Section C makes it more expansive, that's a determination that's going to have to either be addressed specifically by legislation or it's going to be addressed by the courts when they determine these issues. As far as other aspects of the statute, I would note that, and I was not there for the testimony when this statute was brought in to effect back in 2020, but what I would simply point out is that this statute does bring with it, it's not a on the record appeal strictly, it is a de novo on the record review, which also allows testimony to be offered by the appellant. It doesn't say that the testimony is only the appellant's or whether it can be other people he or she brings in. And so the court also can allow other evidence beyond that on good cause shown. And so I just want to note that the practical impact of this is that while, yes, there are 1 hour hearings that are taking place, there's also disputes that will likely take place as to whether there will be additional evidence taken. And so it's not a true appellate review like we would think of the Supreme Court looking at the record. It is a new case on which the lower record is permitted to be utilized and it's built upon. So in that regard, the courts are not simply reviewing what decision DOC made to say whether there was, whether it was clearly untenable or whether it fit within the statutory parameters. But in essence, the court is making that decision anew as a de novo hearing. And so that is something that does take up court time. It does require scheduling, and we will certainly do our best to bring the cases in to address them. But it's not all, it's not just a bunch of, we'll say 1 hour hearings necessarily. It certainly can be significantly greater than that in certain cases. If good cause is shown for expanding. But again, there already is a provision that allows testimony. So it's the judge, he or she will have to make these determinations in the first instance. And this is a non-deferential review and a plenary review as being de novo.
Judge, do you see if it was spread out to the courts where the petition started at that facility and it was at that court? in that area instead of this one court in Washington County? Do you think there'd be some issues revolving around that with different decisions being made?
Well, I think irrespective of whether it's in Washington County or spread out, we're going to have, it's not always going to be just one judge necessarily, whether it's rotation or having other judges to come in to assist when we have a large number of cases that need to be addressed. And so I do support, and I've talked to other judges about this, we do support the idea that it is sent out to the venue requirements that we would have, which would be in the county where the jail is or in the county where the individual was being supervised. And that relieves Washington from having all the cases filed there with one judge. While yes, you would gain some type of consistency, perhaps you're also having a situation where you're just loading up that one county with numerous cases. And as a practical matter, there's another consideration that I think Senator Sears actually touched on when he talked about constituents talking about these types of circumstances. You would actually have the potential, if there's an evidentiary hearing, of having someone have to travel to Montpelier from, for instance, Newport to testify if it was an in-person hearing. Because if the venue is there, that's where the case is heard. And so that's why the venue consensus that we reached also included not just the area of the facility, but where the individual was being supervised at the time of the revocation, because that's where the evidence will be. And having it in that county would minimize the impact upon, for instance, whether it's DOC or other witnesses who might have to be testifying. And while I recognize that we're currently in a remote world, oftentimes for these types of hearings and other hearings, we are, as we all are hoping, are moving back in person in court. And so this is something I think we would see in the future, that the spreading it out with the venue would also help to address.
So I'm just trying to understand, there isn't anything in the statute that requires it to be in a particular venue. And so that seems to be an administrative thing that you folks can work out. I mean, we didn't set that legislatively, and that's something in terms of implementation. So I guess I just wanted, to note that. I'm just like, you know,
without us.
yeah, you don't need us to make that kind of change.
Well, what happens now is it falls under the general venue provisions, and that would allow someone to file where the appellant is residing or where the defendant. And in this case, that's the State of Vermont Department of Corrections. And so absent a change, the standard venue provisions would continue to apply and would allow individuals to file in those different jurisdictions.
Representative Wood, if I could explain a little bit why so many have ended up in Washington. That is often the default with a lot of prisoner litigation because the department is based out of Washington, as I just explained. And in some prisoner cases get tripped up if the person lived in Barrie, but now is in Newport and they sue in Newport. For a while, there was a trend, for several years, there was a trend of the department moving to dismiss those cases, saying that saying you weren't really domiciled in Newport. We just put you there. You're actually from Addison or wherever you're from. And so our advice has often been just file in Washington so that your case doesn't get dismissed, so that you don't end up in a big fight about where you really lived and so on and so forth. And so that's been a product of that. But going forward, I think that it's perfectly fine for our office if there's an explicit statutory rule that says instead of the basic venue provisions applying.
And so so this is my lack of information or knowledge about these particular statutes, but so there must be some other procedure or statute that references, Judge, what you're saying, because it's not in this particular subchapter.
Correct. There's nothing in Title 28 in this subchapter which addresses the venue. It would be found in other areas of Vermont law and what would happen if you added it to this section, it would then say notwithstanding other venue provisions, it has to be brought here. It would then make it very clear that for these proceedings, they're not following what we would call the general venue statutes. And there are some that the legislature has adopted. For instance, there are some that the legislature has said certain cases must be brought in Montpelier. I'm sorry, in Washington County, because they involve the state. So it's not unique that the legislature sometimes makes that determination to either say where they have to be brought in a single court or spreads it out.
Thank you for that clarification.
Other questions? So it really appears as if you folks need to continue having conversations between the three entities to really maybe clarify even more as you get into the nuts and bolts of it. But I think also we might want to just recommend that the committees of jurisdiction during the session really look at this section of law and maybe clarify the difference or the similarities between C and D and what our intent is. I don't know. I mean, I'm just putting that out on the table.
I would suggest that we've had a couple of issues that have come up with justice reinvestment too. And we're just in the middle, haven't finalized. Maybe we're going to put together, every year we do a miscellaneous judiciary bill. Maybe we should do a miscellaneous justice reinvestment bill that would work with Michelle or whomever is going to, council is going to do it, to allow us to look at minor changes. We'll obviously have something coming from the last meeting on the last meeting when?
November and December.
November and December, that committee, and particularly the racial disparities finding. So it seemed good to put together one bill, and maybe the Department of Corrections, the Defender General, the Prisoners' Rights, and the Attorney General could look at what it is they believe needs to be adjusted. I'm sure there's some other things that we've tried to do. I mean, we spent a lot of time last year working on the good time changes to that legislation. So I think it's similar. Anytime you do something major like justice reinvestment, you're going to have things that come up. This appears to be one of those.
That would be the best path to go forward.
So if you come up with in any area of what we've been trying to do, obviously COVID just threw a monkey wrench into a lot of these things. But from what I hear from Prisoners' Rights, it isn't as much of a problem. And I was, I think Matt, I'd be happy to sit down with Matt Valerio. I'm sure, Senator.
I am not a senator.
I'm sorry. The Dean of the House.
Give it to the
The old lady
committees.
that's been around.
The
a
old
while.
lady that's been around for a while. The three of us could perhaps meet with Michelle or whomever and some of these things
That may be the best way forward if people are
for
agreeable.
corrections policy.
Yeah. I think that makes sense. That makes sense. Anything else from you folks, the three entities? Or we move on?
No, thank you for having us.
Great, thank you. And
Thank
keep
you.
talking.
Thank you very much.
We'll continue.
Nice to hear from you, Judge.
Thank you.
Welcome to your new position.
Yeah.
Well, I look forward to working with each of you and the entire legislature as I go forward. And also the Justice Partners, I was really impressed with the way everything worked out this week. We were able to have a nice discussion and reach consensus, and I look forward to continuing that.
Sounds great. Thank you.
Thank you. Have a great day.
I don't think I'm going far.
No, you're gonna probably be glued there for a while.
Yeah.
So we're gonna shift gears a little bit. One of our duties as the Oversight Committee, there was language put in. It was House Bill 435, which pertained to really looking at the operations within DOC and interim commissioner Jim Baker, who worked with the respective committees to set up some structures within DOC to really start changing the culture of DOC. And the bill put in some tools to do that. One of the sections of the bill required a report back to us, and it was due in December, but seeing that we're not going to meet in December, we put on this agenda. But it deals with the Criminal Justice Council and DOC to develop a policy or a proposal for governing minimum training standards for our correctional officers that go through their training complaint investigations to see if there could be clarification and uniformity in that, and a process to certify and decertify correctional officers. This is a very, very complicated subject, all three pieces here. This is the first time that we're hearing the report of what they've been doing to this point in time. I don't expect this issue has come to a conclusion. I believe there'd probably be a lot more work done on this. It's a work in progress. It's going to take maybe longer than what we had anticipated. So we have the folks here. We have the Commissioner of Corrections, Al Cormier, is with us. And on Zoom, we have, is Rose. Rose hasn't come in yet. We have Heather Simons. There's Rose. Rose Weber from DOC. And then Heather Simons, who's now the Executive Director of the Criminal Justice Council, as well as Bill Sorrell, who is the Chair of the Criminal Justice Council itself. So I'm not sure who's going to be starting here. I'll hand it over to the Commissioner at this point to start us off, and then we'll go down in whatever order works for you folks. But remember, please identify yourself for the record when you first start to speak.
Thank you very much. Yeah, this has certainly been an important topic for us. It's something that we've worked very hard on internally and then with our partners. So I'll hand it over to our Chief of Operations, who's taking point on this for us to make sure you get the most expert testimony on the.
Welcome, Al.
Good morning, Al Cormier, Chief of Operations for the Department of Corrections. So thank you for the introduction on that, Representative. We've been working on this for a while. Myself, Lieutenant Colonel Keith Baranow, who is completing a fellowship with us from the U.S. Army, has also been working on this project in conjunction with the council. We put together a preliminary report for the council last week. We met with them as a group, presented the challenges that we had identified. And we've also had conversations, myself and Executive Director Simons, regarding the heavy lift that this will entail for both agencies. I think, as you know, Director Simons came from the Department of Corrections, so she has a good background as to the training and the academy that we currently run and our processes that are currently in place. Where we go is full-on needs assessment basically being completed to really take a look at the budgetary implications and the staffing resources that will be needed to lift this up. Some of the challenges we've identified are statutory changes around the definition of a correctional officer, statutory changes in Title 20 around the certification, decertification of law enforcement, whereas Department not considered law enforcement. So we need to make that determination. Is corrections going to be law enforcement or not? Or does the statutory language change move to include corrections as its own entity? So Director Simons and I, as I've said, have had some of these conversations. We're willing to push forward as a group and see where this takes us. But we know it's going to entail a lot of work on both sides. And I think the staffing resources are going to be one of the big ones.
What a, Well, we knew when we were working on this legislation that this was going to be a very complicated and a deep issue, and that's why we had the language that the council and DOC would work towards a proposal.
This was something that was done by
By
your
me.
committee and government operations or just you?
Well, it was done by,
I don't remember this.
it started in my committee. And we did do some work with House GovOps because we were setting up a monitoring commission, an investigative commission as well. So we worked with them with membership. And we also were working with DOC and BSEA on this particular language here. So it really, it's a deep piece of legislation that really gets into the operations of DOC. And it was really being encouraged by Commissioner Baker to really start putting some tools in place for corrections as a result of the situation that occurred in Chittenden County with the sexual misconduct, and to really start addressing that. And part of it is really supporting our correctional officers in terms of validating their experience as a correctional officer and elevating it is a profession for people to get into. Okay. Jenny?
So thank you. This is totally new to me, so I'm going to ask totally naive questions. But when you look at a forest, it becomes overwhelming, and then sometimes it's important to look at individual trees. So I'm looking, for example, at the minimum training standards for correctional officers. And have you started making progress on any one of these individually? It sounds like you're really looking at the whole picture and trying to solve the whole thing all at once. Have you started looking at individual components of the charge and made any decisions or given direction where you're going?
So, yeah, we have, and, we have a 5-week training academy. We have a very robust curriculum in our training academy now. Part of the recommendations that came out of the DRM report were to add an additional week of training to our curriculum. We're currently working with the Moss Group, who was involved in the drafting of the DRM report. We are in
DRM report.
DRM,
They're not familiar.
Sounds right.
Correctional facility that came out of the 7 days article. So one of the recommendations in there was additional training that include equity, bias, responsive training. So those are things that we are working on now. We are to expand those offerings. So the Moss Group is continuing to assist us in developing that curriculum. The other thing that the Moss Group is involved with the Bureau of Justice Administration right now as well, on bringing standardization to correctional training academies across the country. So our director of our training academy, Jim Rice, has been working with the Moss Group on that, separate from the work we're doing in state with the Moss Group. So while it's not a certification program, it will eventually lead to an accreditation program through BJA is the hope. So with our work with that, we're seeing an increase in the training that we are offering. So that is one component that we are looking at.
So as you're doing this and you're changing the minimum standards for correctional officers, and obviously you're focusing in one of the areas that was so key at South Burlington, sexual misconduct and equity issues. Are you keeping track? How are you measuring the success of the outcomes associated with the changes that you're making?
That's another segment that we're working on with the Moss Group around the data collection for that, for around retention issues, around misconduct issues. What kind of issues are we seeing from misconduct? Where are our retention rates? So those are data points that we are currently looking at as we build this process.
So you are collecting the data. You have a rubric for doing that. Yeah.
But it's really too soon to have any outcomes because they're
Yeah,
just
well,
starting to.
Kind of soon, right?
It might be good, Al, what are the qualifications that currently to become a correctional officer? What's the educational level? What's the experience level? And what is the pay grade? It might be good for members to know that because that's the real starting point.
Absolutely. So the qualifications are high school diploma and 2 years of work experience. So it is, those work the qualifications are quite minimal, to say the least. Starting pay, I think, is a pay grade 19, which is just under $20 an hour. But what we're seeing, we've also, as part of 435, and we're at 56 now, and the creation of the investigation unit, which is in statute. Part of what we've done with our recruitment and retention strategies is create an enhanced background check process. So what we've done, FBI record checks on, criminal record checks on our hires, we've never really delved any deeper than what comes back on that paper. Part of this new enhanced background process is a social media investigation into the new hires. And we've actually been able to screen out a significant number of staff that we did not feel met the beliefs and the structure that the department was looking for in these individual candidates based on, whether it was postings that were sexist or biased or racist. We were able to screen them out immediately. And what we've seen is a higher caliber of candidate come through our academy. The first academy that had gone through this full background investigation process was the academy that graduated 2 weeks ago. There was 15 individuals that graduated out of that class. Through that class, we didn't have one resignation. We didn't have one test failure. We didn't have any test retakes. That is outstanding for us because that is always something that we run into is we see people drop out of the class. We see people that just don't grasp whether it's the adult learning theory, but we did not see any of that. So again, that's part of what we're looking at. And to Representative Evans' point, it's too early to tell. Maybe it was a fluke, I don't know, but it was a good shot in the arm for us to say, okay, maybe this is working. And what that will eventually do will also reduce the need for investigations and misconduct cases going forward.
Or grievances.
Can I?
That are,
Thank you. Al, you mentioned, and maybe I'm mishearing it, but you mentioned, is corrections going to be considered law enforcement? Can you expand on that?
Right now, corrections, we fall under Agency of Human Services, as you know. So we're part of the criminal justice system, but we're not considered law enforcement. We're not sworn peace officers. Our staff are not armed or considered a law enforcement officer. We don't have powers of arrest outside of probationary violations. We can arrest on violation, probation, or parole, but it's only for those that we supervise. So we are not considered a law enforcement agency in that realm.
And is the intent to?
That's what we've got to look at. I don't think we should be a law enforcement agency. Should we increase our standards? Yes. Should we build our curriculum and our training academy? Yes. But as far as law enforcement, most Department of Corrections agencies across this country are standalone agencies, right? Standalone departments.
The term corrections itself would imply that.
Correct. And that goes back to the statutory language change that would be required for the definition of a correctional officer. As it stands now, it includes correctional officers, community correctional officers, and probation and parole officers in that one definition. Well, those are clearly three extremely different jobs.
Yeah, and it goes on, I'm looking at the definition, and it's supervision or monitoring of those folks who are under those like parole, probation, serving a sentence, whether inside or outside of a facility, and who has received training that's been approved by the Commissioner of Corrections. So, and we kind of looked at this within my committee, knowing that this definition may need to be cleaned up. So Butch and then Dick.
Al, good to see you. It's an interesting question. My ears pricked up when you talked about is a correctional officer, a law enforcement officer or not. As we continue to introduce legislation requiring your folks, not just those working in the facilities, but also working on the street, we keep asking them to do more and more law enforcement duties. It's a tough question you're going to have to answer. And I know you and I are not probably on the same page on this one, but that's okay. The conversation started. But I do have a little bit of a worry when I look at the agenda today. And, you know, we're talking now about certification of correctional officers. We have that process in law enforcement. And then I look at investigating complaints. We have that process under the law enforcement arm of state government. And so on, investigating units and all those things. Seems to me, and this is my soapbox, and you know it, seems to me that you're training in a vacuum. Because we have other facilities that do this type of training, and you're off still in St. John's.
You want to clarify that, Butch? They're not at the Pittsburgh
They're not in
Training Academy. They have their own academy.
Your training is not conducted in Pittsburgh with our training academy down there. You have your own academy. As my soapbox is, you know, I think you should be all in the same spot. A lot of work to do. But if you're developing all these standards that we're asking you to, are you developing those standards in a vacuum? Or are you developing those standards in concert with law enforcement? I would hope that, personally, would hope that you develop these standards in concert with law enforcement. So our state employees and the public know the boundaries are. And don't have two separate sets of standards. And I think the Criminal Justice Council will they could look at that to make sure that you're parallel with other agencies.
That's part of the conversation that Director Simons and I have had is how do we move forward with that and what does that look like? Because it is going to be a big lift and it's going to take, you know, the resource component of it. You know, we talked about the academy being in Pittsburgh. I know they have the cottage is open now, but you know, we're at 35 to 38 weeks of training just for correctional officers right now in our academy. And that doesn't even include the ongoing training for trainers, recertifications. We're down about 3 weeks a year that there's not a training happening inside of our academy. So that's something we need to take into account. You know, speaking with the Maine Department of Corrections, they're in a similar situation, but on the opposite scale, right? Because their corrections academy is with the police academy, but they're not. They're feeling they're trying to pull away because it's not correction specific enough for their staff to get what they need.
So a clean slate right now. You can work with and talking with other people. You can develop something that could work.
Right, and that's part of the work that the Moss Group is doing with the Bureau of Justice Administration to bring a consistent 4-pillar model across all agencies across the country, which they must adhere to. So that, you know, there is some oversight there. I think the other component of it is the Corrections Monitoring Commission that goes into effect January 1. That will certainly provide oversight and a level of transparency forward in another venue. We do have a seat on the council. So, you know, being there is important and having those conversations, ongoing conversations. and that ongoing collaboration that is successful.
Thanks. Don't forget, I'll get on my soapbox again if you do.
Anytime, anytime.
Thank you.
We're trying to figure out what's dinging on my iPad.
Dick is singing.
I need technical assistance. But anyway, but I wanted to suggest that I think it'd be a good idea to have one academy for all training of corrections officers as well as I think the Criminal Justice Training Council, even though you're not law enforcement, and I agree with that. I think having it at one place, I think would be a good idea. Just from the economies of scales, and there are similarities. For example, probation officers do have a power of arrest, used to have, I think they still do, power of arrest over over probationers. I believe that, and parolees. I know that on the local level anyway, there's very close working relationships with law enforcement and our local probation officer, and I'm sure that's true everywhere. They even do the sex offender check together because many of them are on probation or parole. They do a lot of things in conjunction. So I think it makes sense to, I don't know how the Criminal Justice Training Council feels about it, but I think it makes sense to have everything at Pittsford. I wish it was a little more central and not representative.
It's great for me. Great for me.
I know, it's very central for you, isn't it?
It's only up Route 7 to center of.
Yeah, no, but anyway, I did want to make that point. I think that, but I do think it should, I would not expect a corrections officer to be a law enforcement officer.
We were, when I went to the academy in 1994, we were in Pittsburgh.
Yeah.
So there is a history of us being in that location. Different training academy sites throughout the years.
I think there was an institution at Pittsburgh that closed that ended up being used. I can't, was it
It's a sanatorium.
sanatorium?
Yeah, it was TB.
Yeah.
It was the
Tuberculosis. So that's why it's at Pittsburgh. Not in Waterbury,
Excuse me.
and not in Waterbury.
No,
But the corrections used to be in Rutland, right?
we were at St. College of St. Joseph's for a couple of years. We were in Waterbury when the Dale Women's Facility closed down. And then when Irene hit, that's when we went to another location.
Anyway, good.
So we knew in the committee when we were working on some of these issues, we knew that there's many layers and a lot of controversy around some of this, particularly when you get in certification and decertification. Particularly if you're going to look at the definition of what a correctional officer is. So we said, let's have the folks look at this, come back with a proposal. It's going to take longer than the next few months and maybe another year before this is really clarified. Anything else from you folks before we transition to the people on the screen?
I would just add that while that process is complicated and will certainly take a long time, as Alice has done a nice job of detailing, to your point, Senator, it doesn't mean that the department itself can't continue to promote the professionalization, raise the standards for corrections officers and for all of our staff. And that's something that I think Commissioner Baker did a nice job of really instilling in the department, and something that I will continue, and I think the department as a whole will promote professional development of our staff, the professionalization of the staff, and ensuring that people have the tools that they need to be doing the right thing, that we're screening people in the right ways, from day one and even before day one. So we can do those things in concert with this effort, and whatever the outcome may be, the department itself will continue to take that on.
And can I just ask, is implicit bias training part of the training that you're doing now?
Yeah, and I think that is that area is a growth area too, where there's more that we can do on diversity, inclusion, equity issues. That clearly, we might not have focused enough on in the past. That's that.
Thank you.
So this is a good segue into Rose Weber, because Rose Weber is the director of your Office of Professional Standards and Compliance, and that was a new office that was established last year. And I believe Heather Simons was the head of that prior to her going to the Criminal Justice Council. So Rose, I don't know if you want to weigh in at all after your boss has already weighed in.
Sorry, Rose.
Thank you. I think Chief Cormier really did give a good summary. What I will emphasize is this certainly is complex. A lot of consideration needs to be taken here across the board. And I think that this is a process where we can't rush into this and really taking time to evaluate all those factors. And also defining what is our ultimate goal here. Is it defining the certification, decertification of correctional officers for that professional standard of what a correctional officer is, or is it more about streamlining training and where that occurs within our system? So I think just making sure that we're defining what our goal is in this whole process, because it is significantly complex, and also just having the opportunity to lay out what we're currently doing, what we want to move forward, and taking an opportunity to see what our strengths are and where our weaknesses are and how we can work together to build upon that. Thank you.
Questions? Okay. Thank you. So let's go to the Executive Director, Heather Simons. She's the Executive Director of the Criminal Justice Council. And then after that, we'll go to the Chair of the Council, which is Bill Sorrell. So Heather, welcome.
Thank you. Good morning, committee members. For the record, Heather Simons, Executive Director of Vermont Criminal Justice Council. We just lost the chair. The general had to hop off to another meeting, so you got me for the duration, and thank you for having me. I think that really just, I will do my best not to be redundant in terms of the layout that you just heard from Director Weber and from the new commissioner, who I haven't met, but welcome, and Chief Cormier. This is indeed daunting process, but one that I think for many of us has been a vision for a couple of decades, and the vision really centers around a common justice center and a state of Vermont that really endorses and supports the idea that we are all working together towards one Vermont that's safe, that's inclusive, that is focused on restorative justice principles, and that is standardizing and using resources in a way where we can partner and meet up in areas where we know that we do some of the same things. And that usually lands around training outcomes, training competencies, and relevant skills. This particular project is going to be, I think, to Chief Cormier's point, something that requires a full needs assessment. And when I say needs assessment, I don't mean whether we need it or not, but really do right by the corrections profession, which we all know, and I will say has been quite a process to have these discussions with Chief Cormier from a different seat and a different lens on how complex corrections is, and that the specific competencies that they have to not just deliver, but monitor, and to the earlier point around data, track. And tracking data in a culture like corrections is not, that's not small. And what the Corrections Academy is really good at is making sure that they build up those specific trainings so that these folks that graduate can enter into the facilities and be safe, follow the directives, make sure that they're true to the contract, and also provide any kind of content that shows that whatever skill's been delivered can also be defendable. And I'm certain that they're well on their way. I'm a little bit biased because I worked there and I supported it, and I already know how gifted these trainers are and how the academy director, how, the stamina that he's had to getting it right. So that's not just a plug from me for corrections, but really more of a statement about how far they've come. I know they've had eyes on expanded training. I know they've had eyes on content that allows for creating more relevancy to the profession in terms of expectations and shifting a culture. And that includes addressing sexual misconduct, harassment, principles that move past implicit and explicit bias and really are laid out in terms of skills. What does it look like to be in a safe corrections environment? And what does it look like to be in a corrections environment that's respectful? And they really are pros at what we call instructional theory into practice and making sure that they attach those skills to the training content. And we are all in agreement that certification and decertification need to partner. And really what that is readiness for the workforce and accountability. And one of the challenges that I think we've all had in our various agencies over years is that we haven't connected training to accountability. And this model would allow for that. We can't get in front of what current issues and challenges are for practitioners if we don't know what they're being held accountable to. And that's been a challenge, not just in law enforcement, but corrections. And we know that in other areas. Capacity, I think, is a challenge. The capacity for us to put resources on this full assessment. I think it's great that they're already working with the Moss Group, who I know has done national work with academies across the country. So that's also helpful in terms of taking a look at the feasibility of where we're going in partnership, how big this could be. And the Moss Group also writes curriculum, develops curriculum, does the checks and balances in terms of making sure that it's defendable. And I think they're a terrific firm, and I'm glad that Corrections gets to use them. And I miss working with them, so I wish they were here with the academy. The last thing is really just to make sure that there's some understanding that there's a lot happening here in Pittsford. We have expanded council that went from 12 to 24 members. That's very diverse in representation. Corrections has a seat, and we want to continue that. The workload around S-124 includes the supervision, the attending and nurturing and feeding of 17 committees, subcommittees, and work groups. All of them have relevancy, I think, to the work that Corrections is doing, but we have to prop up where we're at in law enforcement, and that is enormous. We have an academy that's going right now, which generally starts in February, but we're all aware of the staffing crisis in law enforcement as well. So we began an academy in October, and we'll do another one right after graduation at the end of February. And that is a heavy lift. It's a huge ask to staff who are already working honestly around the clock to make sure that we have the operations tended to, that the committees are moving through with each of their agenda items, and that we're planning for all of the in-service training around Rule 13. So I'm really, I think in my own way, just saying the same thing the chief and the commissioner and Director Weber have said, which is this is a positive partnership, and I think positive vision for how we can be one criminal justice council or center or training site, but a lot of work.
Thank you, Heather. Questions, thoughts? So this is just going to be an ongoing process. When do you feel that there would be a time frame for, I'm sure there's going to be legislative need at some point. Do you see that happening within this coming legislative session? Or is that going to be more long-term, maybe into the next year, 23?
I would see it at least through the next year, 23. And I think for me, I mean, just, the commissioner coming on, we get a lot happening there with the transition. The standing up of the Corrections Monitoring Commission. I would anticipate a lot of direction coming from them on thoughts and ideas of how this specific topic could progress. So working with that commission on next steps, I think is going to be important for us. At this point, they've, 17 subcommittees already established. And 18th, I don't know.
Yeah, they have another one.
So I would certainly ask that push this at least to 23.
So what I would recommend is probably a check-in this coming legislative session from the respective committees, just to, and see how it's developing. And I'm sure the VSEA will be weighing in at some point as well. Okay. Any other questions on this before we transition to COVID? Thank you, Heather. Thank you, Rose.
Thank
Good
you.
to see you.
Thank you.
And I think we're going to keep the two folks up here in the hot seat.
We're very popular.
Yes. So the other thing we wanted to do is also get an update in terms of COVID-19 and what's happening within our facilities. We are aware that you had outbreaks over the past, and then it kind of leveled off where you didn't have any, and now we're seeing St. Johnsbury, St. Albans, we're starting to see a creep up of some cases. So if you could give us an update of what is happening, what procedures are being put in place, also what's happening with the staff as well, COVID.
Yeah, COVID has been a vexing problem across the state, across the country, and certainly for frontline staffs, including the Department of Corrections across the board. So, we can talk through some of the specifics, but I reiterate that the department is heavily focused on COVID and mitigating impact. I think while we do have surges, from time to time in different facilities, by and large, the protocols we've had in place have been quite effective at keeping those down as best we can. I would also just highlight, something that we talk about frequently, but Vermont is the only correction system in the country that has had no incarcerated person die of COVID-19. Staff person die of COVID-19.
Knock on wood.
Yeah. I'm not saying that's entirely because of the things the department has done, but I do think those were huge contributing factors to mitigate those outcomes for folks. And so that occurred obviously before I arrived. And so kudos to everybody involved in that effort, and particularly Al and his staff in determining what the right protocols were and putting those protocols in place and having them be so effective. I would be happy to give you COVID-19 numbers, but all the numbers that I brought in here, I think have changed since I arrived. So I know we have Rachel on the phone, or Al can speak to some of those numbers. And if you want to get into the specifics of the protocols and stuff, certainly I think we can do that with you.
So would it be Rachel or you, Al, which is what?
Rachel has the updated numbers because as the commissioner said.
Okay,
Yes.
Rachel, well, if you could just identify yourself for the record.
Thank you. I'm Rachel Feldman. I'm Principal Assistant and Public Information Officer for the Department of Corrections. And as Chief Cormier and Commissioner Demmel mentioned, we have had a lot of changes this morning. We are currently at 17 active positive staff cases and 10 active positive incarcerated cases across our entire system. our 17 positive staff cases are at Northeast Correctional Complex, where we have 4. At Northern State Correctional Facility, where we have 9. At Southern State Correctional Facility, where we have 3. And at Springfield Probation and Parole, where we have 1. Our incarcerated positive cases are 4 at Northeast Correctional Complex. We actually had 7 more clear this morning from our outbreak, which means that 16 people have cleared from that outbreak. And this morning we received results from testing that was taking place on the 10th. We have 5 incarcerated positives at Northern State in Newport for a total of 10. And Northeast is testing again today.
So I guess the question, I'd like to do a little deeper dive in this in terms of for folks that, well, the incarcerated folks more particularly, is it coming from folks coming in newly incarcerated that are carriers or not, or is it happening with folks who are currently incarcerated? How many are vaccinated? And then the same for the staff. How many of those are vaccinated or not vaccinated? And are you seeing the spread happening more within the facility, or is it coming in from the outside?
So to that, I apologize. I did leave out that we do have 1 incarcerated positive at Northwest State Correctional Facility in St. Albans. Unfortunately, the cases from Northeast, Northern, and Northwest are all from general population. Up until now, for the past few months, all of the new incarcerated cases we've been seeing have been detected in intake quarantine, meaning they're coming to us directly from the community and are not reaching general population before they're medically cleared of COVID-19. But these 3 cases are particularly concerning because they are in general population. So we have all of those facilities on full lockdown. In terms of the vaccination status at Northeast for that outbreak, hold with me 1 second. So 14 of the 20 are vaccinated, 5 are unvaccinated, and 1 is partially vaccinated. For the 5 new staff cases at Northern State from this morning, 3 are vaccinated and 2 are unvaccinated. 3 are unvaccinated, 2 are vaccinated. And I will need to get back to you on the vaccination status of the other incarcerated and staff positives. But I can do that for you by end of day.
Rachel, if you could add, what's that?
Email those.
Well, I was going to ask, could you update with regard to the entire population in terms of vaccination? Where are we in that set of numbers?
Oh, absolutely. So for our incarcerated population, we track these numbers weekly. Our population for all 6 of our in-state facilities, as well as Tallahatchie County Correctional Facility in Tutwiler, Mississippi, is at 73.8%. So that leaves us with 26.2% that are unvaccinated. And that goes from a high of 93.3% at Chittenden in South Burlington to a low of 59.3% at Northwest in St. Albans.
Could I follow up? What is the department's set of procedures for, in the military now, under the new order that President Biden put out, someone isn't ejected immediately if they don't get vaccinated by the deadline. There's a period of education, counseling, et cetera. Are there similar efforts in the prison to engage one-on-one with people who are hesitant to bring those numbers up?
A clarifying question, are you referring to our incarcerated population or our staff?
Well, both, I suppose. I mean, your numbers were actually a little the reverse of what they normally are in terms of, in the first instance, you gave most of the cases were among the vaccinated, but generally it's the reverse. So I'm thinking that the department, or I'm hoping that the department has some sort of relatively aggressive education persuasion effort with, let's say the 59% in that one facility who are vaccinated, that's leaving almost half unprotected. What is the department doing along those lines besides just simply offering the vaccine? And maybe it's a question for the two of you as well.
Yes, I can start with what we have done thus far, and then Chief Cormier, I'll turn that over to you. So some efforts that we've undertaken, every incarcerated individual has a tablet. This summer, we did put out a survey, anonymous, voluntary, to our entire incarcerated population, asking for their questions about the vaccine, their concerns about the vaccine. And then we filmed a video with Dr. Levine, as well as with Defender General Valerio, and it answered all of those questions. We distributed that to all of the tablets. We also have information available that has come from the CDC available on all the tablets. And our staff, as well as our medical staff, are providing information to incarcerated individuals. So it's not just, do you want a shot? It's, here are the things you might have been hearing, and here are the reasons why they may or may not be true, and here's other information for you. Then for our staff, which when it comes to the staff who have attested to being vaccinated, we're at 77% across our in-state facilities. For our staff, it really is everyone's personal choice, but when somebody does not attest, they are testing twice a week, and everyone in all of our facilities is required to wear a mask regardless of vaccination status. So that is our mitigation effort there. Chief Cormier?
Just one last question. Are those tablets, can they access the internet?
They
No.
can, but not fully. It's not free reign on the internet, but there are internet services.
Okay, so they're not open to social media, for instance?
No, they're not.
Okay,
Oh, God, that would be a mess.
just checking.
They have access to video visitation, email, instant messaging, books, movies, music. So those services are apples, but not a full 100.
Got it. Oh, one last question. I'm sorry. I forget what they're called, but the inmates who are in a kind of counseling advisory role, there's a name for the program, which is
The Open Ears program?
Yes. Are they working on the vaccine hesitancy problem?
We have utilized them in some instance at the onset of this. So that was part of it, that peer-to-peer model, encouraging others. Can't really say whether we saw a lot of success, but it was a tactic we used. Part of the issue is we don't have a mandate for the incarcerated population with our staff. There's no, what do you do, put them in jail? We've talked about those that are unvaccinated and putting them into one unit, but just the housing the way it is right now is with our isolation units, our quarantine units. To Rachel's earlier point, 2 months ago, we were catching everything coming through the door. That intake quarantine process worked. The initial testing, testing at day 0, day 3, day 7, day 12, we were catching everybody. I don't know if it's a variant issue. I don't know if it's a staff issue, but we are starting to see more in the general population area that have cleared our quarantine. We continue to talk with our staff to encourage them to vaccinate, to encourage them to be judicious on the outside with mask wearing and limiting their interaction, but we have no control over that. Even with the mandate, it's still tough. We're seeing our outbreaks, St. Johnsbury and Newport right now. Those are the highest unvaccinated counties.
Yeah.
So that is speaking for itself there. We continue to push, we continue to work with staff. At this point, it's the masking, it's the cleanliness, it's the sanitation, it's the social distancing. Contact tracing. We have a great partnership with the Vermont Department of Health. We do a rapid response team meeting with them every day at 11. Contact tracing that we're conducting is really limits and mitigates the effects. It really does.
I do think it's worth highlighting that the trend has, our trend in the Department of Corrections has trended with the state as a whole. The difference being, we have an obligation to keep people in kind of close proximity, whereas folks in the state have the opportunity to spread out. We don't have that opportunity, but the mitigations that have been in place, I think, have done as good of a job as possible to help mitigate some of that.
Thank you.
Yeah, just a couple of. I have a sense of what full lockdown means, but I don't know what it really means for people that live in that particular unit. I quarantined myself because of close contact. I didn't have it. I tested negative, but I could go out and walk the dog. I could go out of the house. I could drive my car. I could do a lot of things that these folks probably can't do. So what does full lockdown mean? Number one, and how long are you under full lockdown in a unit?
So we have two statuses right now, full lockdown and then a modified operation. So full lockdown is when we have a positive case, an outbreak, and we put the facility into full lockdown. We're not doing intakes. We're not transferring incarcerated individuals from facility to facility. We're feeding it ourselves. Our medical services are being delivered to the unit instead of letting the population go to the med line. And then it's more restricted time in the cell itself. They're allowed out for a shower. They can make phone calls with their tablets at the video visitation. Shut down the visiting, in-person visiting with that because of the threat of anything coming in from the outside. So it stops operations for us to mitigation strategy to take a look at where's the movement, where did the positive case come from, was there any cross-contamination through contact tracing. A modified operation is when we'll lift a lot of those restrictions where there's time in the day room. There's movement out into the rec yard. Half of one tier of the unit can come out to the day room, and then a second tier can come out at another time. Movement to and from different parts of the facility, whether it be for an education service where we set that up, whether it's social distancing and
how long is a full lockdown?
it depends on the outbreak. It's really going to be dependent on when that facility clears, and it's really based on the guidance of the age.
What about counseling and other things that would go on in a normal?
So our mental health providers are checking in with the population on a regular basis. We just started a new program. It's an app on the tablets. It's called Breaking Free. It's a mental health services application that the population can access with different types of therapy treatment models. It's a web-based service that's downloaded onto the tablet, so they get access to that. We've gotten really good feedback on that application. So there's those things that are happening. We're getting people checked and looked at, and it's forward to.
You highlight an extremely valid point, Senator, that one of the unfortunate byproducts of COVID as it relates to corrections is that the thing we need to do to keep people safe is also harmful in other ways, emotionally, mentally, and potentially physically. So the department is aware of that, and we will do, and with any suggestions that you have, try to do everything we can to help offset the impacts of these lockdowns. Unfortunately, not isolating people will continue to spread this illness. We're trying to do all that we can to stop that while understanding the emotional, mental toll that might take.
Yeah, but just the opportunity to go outside.
Yeah.
Absolutely. Understand how
Maybe not today, but
Past couple days.
the increase in, I don't know if it's been an increase in detention, but the commissioner and I were having an informal conversation before the meeting started. And one of the problems that Vermont faces that most states don't is that we take detentioners And how much, I'm sure with the backlog in courts, that we're gonna see some increases. But how do we handle the detention population now? Are they separated in, or do they go right into general after a few days?
So they're quarantined for 14 days. Anybody coming through the door and then the detainee will go quarantined for 14 days. That multi-layer testing with days, intake, 3, 5, 7, 12-day testing regimen, cleared through the medical provider to be released to general population.
Are you seeing a low vaccination rate among the detainees?
It varies. It really varies. Again, it's dependent on the county of origin.
Yep.
Where we see the difference in the intakes. That's one of the first things that we ask, are you vaccinated? We can verify through the VDH website, through our medical provider, and offer the vaccine up when they do come in.
Sure.
Yeah, okay, thank you. Can any of you talk about the severity of the cases? And are these cases being recognized through testing, or are they symptomatic?
Through testing. The majority of them are through testing. The majority of them are asymptomatic cases. We will have cases that will place, somebody will come forward and say, I've got a headache, I don't feel good, I've got a fever. We'll put them in an isolation unit and monitor them and then test them again. But that has been the extent really of the symptoms that we've seen, is the headache, the sore throat, the temperature. Again, knock on wood, not having anybody with significant symptoms.
Since I've started, we haven't had a hospitalization case, anything that reached that level of severity. So that I know there's limited, at least in the most recent kind of surge across the state, that hasn't translated to hospitalizations for us.
Rachel, you gave us a lot of information, a lot of statistics, who's, the percentage of vaccination, who's not, from what facility, whatever. Could you put that together and send out an email to the committee members with that?
Absolutely.
I know the numbers will change, but at least it gives us a basis to work off of. And that will help us understand more the nuances in terms of what part of the state, staff, incarcerated. It would also be good for the population down in Mississippi, how many of them are vaccinated or not? And is that population pretty stable, or has there been a lot of transports back and forth between here?
That's been a very stable population. We can bring people back, but we haven't sent anybody out for almost 2 years.
And what's the number of folks that are down in Mississippi right now?
145.
With, I think, an expectation that a few will be coming back in the next week or so.
And do you quarantine them when they come back?
Yes,
Even if they're
tested
back?
before they leave,
Okay.
and they're tested when they get here, and they're quarantined for 4 days.
Well, thank you for the work that you're doing. I know that the former commissioner phrased the situation within the DOC facilities are very similar. Year ago, very similar to a cruise ship situation, that you're on board and you can't get off.
Well, excuse me. Cruise ships are very different from the facilities.
Yeah, but in terms of the COVID spread. In terms of the COVID spread.
And the
Well,
buffet.
I just refuse to, I'd pay to go on a cruise. I wouldn't pay to go to.
That's true. But it could spread quite easily because you're in a confined
Things-
situation.
Tend to spread quite easily in any confined area.
That's true.
It's just as dangerous to be in the Hyatt Regency in Atlanta as it is to be in a cruise ship. From personal experience, I can tell you, there's plenty of space.
I just want to give credit to the staff under me that rapid response team and their partnership with Engage, and We're testing every day, getting those results every day. That's Saturday, that's Sunday. I mean, they're working just incredible to stay on top of this. They don't get a break.
Vaccine mandate, I'm really going to be amping up here from the first part of December, I believe. Are you a little nervous about that with staffing?
It's been something that we've been concerned about from the onset of the mandate. And, you know, the staff that are unattested have been great with the testing regimen, the twice a week testing regimen, compliance with the mask. We really haven't seen any blowback, so I'm hoping that continues.
Anything else before we break for lunch and then come back at 1 o'clock? Okay, we have,
You're right on time.
yeah, right on time.
God, Alice, you're on time.
No, my second, too. What happened? Thank you.